Calling our next case and our last case for today, Pueblo versus Haas. Good afternoon. This is a 20-minute grant. Welcome, council. You may reserve some of your time if we do not use it up, and we ask that you do your best to keep track of your own time. And you have 2 minutes of a free fire zone. Looks like we are splitting time, 10 minutes each. Okay, great. Just let us know how much you're reserving and for who. Thank you.
Thank you, Your Honor. May it please the court? Good afternoon. Before I begin, let me start with my appearances for the record. Ray Starks on behalf of Carrie, Pueblo, the appellant today. Before I begin, I would like to reserve 2 minutes for rebuttal. And I would like to note that I am attempting to self-time, so we can hopefully stay on track for that. Thank you. In 1970, the Child Custody Act defined the term parent. In 1978, we had the world's first test tube baby born. In 1981, our nation's first test tube baby was born. And then in 1987, Atkinson v. Atkinson gave us the equitable parent doctrine. Fast forward to 2015, nearly 30 years later, and that is where Obergefell v. Haas identifies that we had a discrepancy in our laws. Same-sex couples were not being honored in the same fashion that heterosexual couples were. They bestowed upon us the right for same-sex couples to be married. With that, there came a constellation of benefits. We've heard that phrase, no Obergefell. With that constellation of benefits, we've got marital benefits that are conferred upon these same-sex couples, and within that comes parenthood. But we come upon some difficulties in this particular case because these parties were involved in a romantic relationship that predated Obergefell. They never had the ability to get married. What they did have the ability to do was participate in a same-sex commitment ceremony. They held themselves out to be husband and wife. They wore wedding rings. They lived together. They shared expenses. And namely, why we're here today, they utilized IVF to conceive a child. And in conceiving that child, they became parents. That was their intent all along. And that is the path that they continued on. Unfortunately, their relationship romantically came to an end. And when that happened, shortly after, the minor child, JPHP, did incur some medical tragedy. He suffered a stroke. And then shortly after that, Ms. Pueblo was no longer able to contact the minor child at Ms. Haas's wish. In 2020, as this court is aware, we did go ahead and file a suit. We are seeking that this court apply the equitable parent doctrine in this particular case. There's been argument that the equitable parent doctrine, there's been argument that we're asking for new law to be created, and I offer differently. We're not asking for new law to be created. We're asking for an extension of the equitable parent doctrine to a population that was not previously conceived. In the 1970s, when the Child Custody Act was implemented, in 1978, 1981, when we saw the first test tube babies being born, and in 1987, when Atkinson v. Atkinson came to life. It's a relatively short period of time when you think about it, but it's moved very quickly. And unfortunately, Michigan law has not yet had the opportunity to keep up with the modern family style, with the modern family dynamics, with the modern family composition. And that is what we're asking the court to do here today.
Counsel, I'm wondering, the State Bar of Michigan Family Law section submitted a brief, and they basically said they didn't think the equitable parenting doctrine is the right pathway in this case, and that they think an equal protection analysis is better, and they largely, I'm segueing off what you were just saying, that that's more in line with our modern custody laws. And I'm just wondering what your thoughts are on that, recognizing you've come here today arguing the equitable parenting doctrine.
Yeah, so I would like to revisit some of my earlier briefs, in even perhaps my initial application to this court, wherein I did have an argument that somewhat paralleled that, and that's going back to that elastic expansion or elastically expanding the definition of natural parent in the same way that we saw in Lefevre v. Matthews. They decided that there was a physical connection, so we could go ahead and expand that definition. And I'm not opposed to the court moving forward in that fashion and expanding the definition so that it can apply to Ms. Pueblo and others like Ms. Pueblo. I'm not opposed to that. That is something that I had offered, I think, from my initial stages with my motion for a summary disposition response at the trial court level, and it's something that's still kind of been laying in the wings, perhaps not as prevalent as my request for application of the equitable parent doctrine. For me personally, for whatever reason, I do feel that the equitable parent doctrine, it seems to be a more clear path, but I'm open to what the court feels is best, just hoping that it does provide what I need so that Ms. Pueblo can see her son again.
And what do we do, I know opposing counsel has raised in his briefs concerns about that if we do expand to this category of people, that there will be all these other ramifications with estate planning and other areas where spousal benefits are at issue. What's your response to that?
So I think I've got two prongs to that. My first one being that this case in particular is not seeking anything other than standing so that custody and parenting rights can be bestowed upon Ms. Pueblo. We are not looking for anything else. And so I think that that's a bit of a red herring. I'm hearing that he's saying that that's opening the door, but I disagree respectfully. And then secondly, as has been pointed out in Amicus briefs, and as was pointed out in opposing counsel's brief, we've seen that other states are already grappling with some of those issues. And so if that is something that comes up, it's, unfortunately what I think is just it is necessary for us to have to deal with if that in fact occurs. Although that's not what we're asking for here. I think there would be a stretch to move the application of the request for custody and parenting time into other areas of life.
Thank you.
Thank you.
What about child support?
I'm so sorry.
And what about child support?
With regard to child support, are you asking?
You're asking for that as well? I mean, that could be open. I mean, if this goes back and there's a determination of parenting time or even joint custody, then child support is in the mix as well.
Absolutely, Your Honor. So just honoring that third prong of the equitable parent doctrine, wherein it would require, under the current language, that the father is willing to pay support. Ms. Pueblo is willing to pay support, and in fact, that is something that we pled in our initial summons and complaint, and that's not something that we've abandoned. We're fully committed.
Okay, thank you.
Thank you. I've heard a lot of concern about the fact that best interest factors have not yet been addressed. And I think that's something that we have learned in reading or in going through these cases, is that inherently something that we must address is what is best for the child. Because we do unfortunately enter a realm of discrimination against the child when we're not opening up the doors for them to have access to both of the parents who were intended to be their parents. That is not the same as an analysis under the best interest factors, but it's absolutely something that I would implore the court to take into consideration. We don't want the child to be discriminated against, to be treated differently, to be adversely treated as a result of not having access to the two parents that were intended to be their two parents. With regard to Lake v. Putnam, we note that highlights, or I believe that highlights a gap in Michigan law, specifically that we have this population of people who were not allowed to get married, who were able to utilize IVF to have a child, but they're not able to exercise parental rights. I understand that the Court of Appeals deferred to Lake v. Putnam in arguing that I don't have grounds to seek these custody and parental rights, but we do ask that the court here today abrogate that case.
Do we need to overturn Van?
I'm so sorry?
Do we need to overturn Van?
Ooh, that's a really good question. I don't know that I have the right answer for that right now. I don't know if I'm able to find my answer for that right now, but I would be happy to address that on rebuttal, if I may.
Thank you.
Thank you.
Mary Mockerman on behalf of Amicus ACLU of Michigan. When parents separate, children and parents need legal protections that allow them to preserve the parent-child bond that is so central to their lives. And that is true whether the parents are married or unmarried. And it's true whether the parents are gay or straight. The question here is who qualifies as a parent. Our brief sets out 3 approaches to answering that question, and we urge the court to adopt all 3 approaches. Each is correct, but each has slightly different parameters. And one of the reasons it's important for the court to adopt all 3 is that if, for example, on remand, the trial court said, you know, I think this family intended to create a child together, but I don't think they would have married, and you had only adopted the equitable parent approach to that question, then the trial court would, you know, maybe deny standing, the case would come back up on another, you know, are these other doctrines available? Are these other approaches available? We have another trip up the appellate ladder. And that's not in anyone's interest, especially when parents and children are separated. Not only does this court owe it to the trial court in this case to provide as clear guidance about who has standing as possible, but it owes it to the trial courts across the state who are grappling with these cases every day with a variety of factual situations, a variety of fact scenarios. So the court has to, really should, adopt all 3 approaches. I want to start with the intentional parent approach, which is, it is the easiest and simplest approach. It's squarely focused on the child, which is what custody law should focus on, and you don't have to look at the question of marriage. So from the perspective of proofs, when you think about it, it's really what is on, who are the parents listed on the birth announcement, not did the commitment ceremony invitation have, you know, a picture of wedding rings on it, right? Justice Walsh, to your question about the family law section approach, what's really interesting is that their approach about the statutory interpretation is really another version of the intended parent approach. And I want to drill down on that a little bit because I think what's quite interesting about the way they look at it is they say, let's look at the Child Custody Act and interpret what does it mean by the term parent. Now, of course, the Child Custody Act has to be interpreted. It's equitable in nature, and the legislature says that it has to be liberally interpreted for that reason. The Court of Appeals here said natural parent means genetic parent or a blood relation. That is clearly wrong. Because if you look at the chart on page 19 of our brief, you will see that there are a whole series of ways that people can establish parentage that is not based on a genetic connection. The overall statutory scheme makes clear that you can be a natural parent without being a genetic parent. For example, under the marital presumption, a father who does not have a genetic connection but is married to the mother can be a natural parent. The same thing with a husband whose wife conceives through through assisted reproduction, rather. So a marital husband is presumed to be a natural parent. A husband who uses assisted reproduction is one. So is a man who signs an acknowledgement of parentage, who later it turns out, you know, he thought he was the biological father, he isn't. He's also a natural parent. So what's very interesting about the family law section approach is that you can do this as a matter of statutory interpretation and say, intended parents are parents. What's quite interesting as well is that if you look at how the legislature defined natural parent for the purposes of the States and Protected Individuals Code, EPIC, this is MCL 700-2114. This is not in any of the briefs. It's something I realized preparing for this argument. There in EPIC, the legislature defines natural parent and again includes parents who create families through assisted reproduction. So the legislature itself has said natural parent includes families created through assisted reproduction.
So counsel, I'm going to jump ahead and Justice Clement's question about Van. So under your analysis, do we just not have to touch Van with all of that? Or are we working around it?
You don't have to touch Van.
Because it's not about equitable parenting doctrine.
Well, we think you should adopt all 3 approaches because we think you owe guidance. Family law is messy, right? There's every possible combination of constellation that you can imagine, and the trial courts every day are looking at all of those different factual scenarios, and so providing looking at all of these approaches will provide the most guidance to family courts and ensure, more importantly than what your obligation to the family courts, it's your obligation to the parents and children of this state to protect those relationships that are being decided every day and that will be decided in light of how this court resolves this case. But certainly, if you don't want to look at the equitable parent doctrine, you could just do the intended parent approach. There's different constellations that might be affected by one doctrine rather than the other, which is why we think you should do all three. But even if you look at the equitable parent doctrine, you don't have to overrule Vann. You don't have to make that decision. This is the only state that requires marriage. It's an outlier. But if you don't want to address that issue, you don't need to, because here, regardless of whether the marital requirement is necessary or appropriate, it is clearly not appropriate for an equitable doctrine to require marriage where the state of Michigan said you can't get married. So Michigan said, essentially, we're gonna unconstitutionally and discriminatorily prevent you from getting married, and then we're going to require you to be married to assert your parental rights. That's clearly not equitable. So a doctrine in equity cannot require marriage under those circumstances. I want to address the question about ramifications in other areas of the law. And there, I think...
I'm sorry, did I miss your third option?
So the third option is the assisted reproduction statute,
okay.
right?
Yep,
So
yep.
under the ART statute, a husband and, if a husband and a wife have a child together, the husband is the parent. That should be true for same-sex couples just as it is for different-sex couples. And I want to emphasize in response to that question, one of the most important things this court can do in this case is make clear that these statutes need to be read in a gender-neutral manner. So when it says husband, it doesn't mean husband. It has to be under MCL 8.3b, and as well as in terms of what a Bergefell requires, you have to read these statutes in a gender-neutral way. So that argument is really to say the assisted reproduction statute has to be read in a gender-neutral way, and you cannot. So for currently married parents, right, married moms, that they have that protection. That is very critical because there's a lot of uncertainty, as a practical matter, for married moms today about what their parental rights are. And then this, as with the equitable parent doctrine, for the pre-Bergefell couples, you can't impose that marriage requirement because that would be inequitable and unconstitutional to condition that marriage-based benefit when people could not marry. And then I wanted to just address the question about ramifications in other areas of the law. So, first of all, if you follow the intended parent approach, you don't even have to get into marriage because the intended parent approach doesn't look at marriage. It just looks at, did this couple want to have a baby together? Different sex couples who have a baby together and actually, whether intentionally or unintentionally, are held responsible and accountable for the children they create. If you hold parents accountable who unintentionally create children, surely we hold parents accountable when they intentionally create children. And with that obligation to support a child also come the rights and responsibilities of parenthood. And so that approach doesn't even deal with the marriage issue, but we're asking you to adopt all three approaches, and the equitable parent and ART approach do obviously require you to look at the marriage question. So essentially what the appellee here is saying that if courts start addressing the impact of Michigan's discriminatory ban on same-sex marriage in the child custody context, courts might have to also address the impact of such discrimination in other areas of the law. The fact that Michigan's unconstitutional ban on same-sex marriage may have implications for other areas of the law doesn't mean that this court should ignore that requirement, ignore the implications here. Courts are already addressing these issues, as you see in the Social Security cases that were cited in our briefs. But I think most importantly, a prior inability to wed, where those cases come up is where there's a continuing implication of that today. So in the child custody context, in the survivor benefit context. This would be a very different case if this was, a will that was probated 20 years ago and the judgment was final. Because then you're dealing with, a final judgment and that whole sort of set of issues. Here, this is a case that is on direct appeal, and so it's a very different set of issues.
Do you want to leave time for rebuttal? I'm sorry.
I think I didn't reserve time for rebuttal, but I know that she
You're-
did, so
yeah,
I will
yeah,
sit down.
thank
Thank
you.
you.
May it please the court, George Parrott here on behalf of the appellee in this matter, Rachel Haas. Best made plans, I had an argument to kind of set forth, but I think probably I'm better serving this panel by addressing the issues specifically brought forward on argument right now. And that is counsel's very apt outline of the kind of a three-tiered approach that some or all of those who have filed amicus briefs would endorse, or what Ms. Starks had addressed in her principal argument. That being that, one, we could urge an elastic approach to the expansion of the equitable parent doctrine that was first enacted in 1987 in the Atkinson case. I would submit to the court that the family law section is correct. We ought not head down that road, specifically because it has always been a function of marriage. And as Lake outlined, Lake versus Putnam, the court was very reluctant to impose a marriage post-Obergefell where none had existed prior to Obergefell. By the way, this notion that the parties never had the ability to get married is simply not the case. There were 7 states in the United States that afforded the opportunity for same-sex marriage prior to Obergefell. They certainly could have taken a leave of the opportunity in those states to do that.
But Michigan made it clear they can't recognize those marriages, correct? So wouldn't that have been sort of futile for purposes of what they were trying to accomplish here?
No, I don't think so. I think under the principle of comity, the Stankovich case talked about recognition of the Canadian marriage. I don't know that there was, under principle of comity, a full faith and credit and a case in Michigan that disqualified those who got married in foreign jurisdictions from being recognized here in the state of Michigan. I think what the constitutional prohibition talked about was that Michigan was not going to endorse that path. And as we know, Obergefell obviously overturned that with a few other states involved, including Ohio. So
they would have to travel out of state to get married to basically have a right to their children. Is that what you're saying?
No, I'm not saying that. Well, first of all, the relationship existed before the child was born.
Sure.
So the notion that somehow they didn't have that opportunity, that's what I'm specifically addressing. The notion that they didn't, as a matter of fact, is not the case. As a matter of fact, they did have that opportunity. They just chose not to avail themselves of that opportunity.
Right, but they did do a civil commitment ceremony, which I know you said you didn't think was.
Well, I appreciate why they did
Yeah.
that, certainly. But the fact of the matter is, if a civil commitment ceremony were the equivalent of a marriage, there would have been no Obergefell.
Sure. Have you ever been to a heterosexual civil commitment ceremony?
No, I have not.
Yeah. Why do you think that is?
Because the prohibition on marriage.
Right. Okay, thank you.
Yeah, I mean, I'm not here. We're not re-arguing Obergefell here. The Obergefell is the law of the land. That's not the issue. The issue is, what do you do post-Obergefell with a scenario in which those that had the opportunity to marry outside the state of Michigan, took no effort to avail themselves of that opportunity, have now a situation in which there was a child from the relationship, by way of in vitro fertilization, and whether in fact we're going to confer custody and parenting time rights by way of standing to the individual who was not the birth mother or the genetic provider of the fertilized egg. So the question is, do we expand that under the equitable parent doctrine? I would submit, for the reasons the family law section argued, and for the reasons that we have argued in our briefs to this court, that it ought not be. With respect to the intended parent doctrine, kind of the ancillary or the argument from the family law section that says, let's get away from the equitable parent doctrine, let's just simply look at the criteria of this particular circumstance. I would submit this court has already ruled on that. And let me address it more specifically. They talk about, in their amicus brief to the court, the existence of a committed relationship, 1. 2, an intentional joint decision to have a child during the relationship. 3, this child being conceived or born during that relationship, and the child looking to both parties as their parents, and both parties holding themselves out to the world as and the child as parents, and accordingly acting as parents. This court ruled on very nearly those identical facts in Barnes versus Judavine in 2006. Difference there was that we were dealing with a heterosexual male who was involved in a extramarital affair with a married woman at the time. And this court, in a 4-3 decision, determined that that individual did not have standing to initiate a custody and parenting time complaint on those same facts. So now we're being asked to consider whether we're going to expand that intended parent doctrine to accommodate a same-sex third party involved in a child rearing situation, childbirth and child rearing situation, where this court previously denied it to a heterosexual individual. Why would we do that? That vitiates the entire 2012 amendments to the Child Custody Act that were taken as a result of the Barnes decision. It vitiates the amendments to the Paternity Act that provided for opportunities for third-party fathers in that instance to establish paternity, given the genetic component in relation to the child. We're messing around with things we need not mess around with. 3, and by the way, Chief Justice Clement asked about whether expanding it, before I get away from the equitable parent doctrine completely, whether it requires overturning Van and certainly Lake. Yes, it does. I mean, if we're going to expand it beyond the construct of having a marriage, then of course, yes, it does that. Because unless this court is going to say, and it's certainly within its rights to do so, that we're going to impose a marriage, but I would submit that the argument in Lake is very, very sound. We ought not to be about that. The gravamen of the Obergefell case, among many, many things in that very momentous decision, was the fact that Justice Kennedy emphasized time and again that really what this is about is the personal autonomy to associate and to form bonds with those individuals that we choose to do that, irrespective of their sex. And so when that's the case, that autonomy includes both the right to marry and the right not to marry.
But counsel, I absolutely, I agree, that's what it says. But obviously, the parties in this case didn't have a choice. So other states have obviously done exactly what you're talking about, this sort of expansion where they've said, would they have gotten married had they been able to? Did they present enough evidence that they maybe would have gotten married at that time?
Okay. all right?
But the child, you did have an option for adoption proceedings, right?
Certainly, absolutely. Yeah. But let's take, not in the context of pre-Obergefell where same-sex adoption, but let me talk about what the implications of that are. The implications of that are, I represented for purposes of protecting his identity, I won't identify him, obviously, I don't have the permission to do that, but I represented a gay man in 2014 who was in a long-term same-sex relationship in which he brought substantial premarital assets to the relationship. They also, the two of them, the couple, had also created a substantial, for lack of better words, marital estate. If now we confer rights on a custody basis, parenting time basis, to this appellant, what are we doing in relation I mean, it's very easy to say, well, you know, we can just do this in a very isolated way. We can focus on just the child custody and parenting time issues. No, you can't. No, you can't. That couple split up. They had no right to a property distribution as a result of their breakup. It became very inequitable. If we're talking about equity, that became very inequitable. It was not the right thing in that situation, but because of the status of the law, that's the way it played out. Now we're going to create a carve-out on this issue. This begs a legislative approach to this issue. Not because this is an important issue. I'm not meaning to minimize it. I'm just saying there's as Appellant versus Smith said, there's a constellation of rights and benefits that run with the Obergefell decision in 2015. There are a whole series of things. It's not just the spousal selection and intestacy issues. There's the wrongful death consortium damages. There's the right to get a pension as a surviving spouse. The list is endless. Some are handled by way of government statute, and therefore, obviously, could be addressed quickly by a legislature. The others are addressed by contract, and certainly would be a product of a judicial determination that they were void against public policy. But the bottom line here is, to address that pantheon of right and responsibility, we need a comprehensive approach to this, not a piecemeal approach.
But isn't that what we do in cases? We will have to address that whole pantheon of issues as they come to us in each case. So the fact that that it may have ramifications, including our decision may contribute to a ramification in another context, isn't a reason not to apply it and decide it here, is it?
No, I'm not saying that.
Okay.
I'm just saying that it will beg a series of equal protection. The very issues that give rise to the concern, the equal protection and due process rights of the individuals that ultimately ended up in the Obergefell decision are going to be played out time and time and time again. And that's why, by the way, you didn't see the family law section, and I'm presuming this, and I don't mean to speak for them, but I suspect it's why the family law section didn't say, well, there's an easy out here, just expand the equitable parent doctrine, and went to this intended parentage kind of approach. It is, and they even acknowledge, these are the kind of issues that ought to be solved by a legislature typically. You're right, Justice Kavanaugh. I mean, I understand that courts are a place of last resort, a place of ultimately providing remedies where other remedies are not possible. But in this instance, the remedies are possible. We have there is a groundswell of support for these types of issues in legislatures across the United States. And it ought to be taken up, and it ought to be addressed in a comprehensive way that doesn't create a hodgepodge or a mix and match of different rights and obligations. We ought to be doing the things to make sure, the last thing we ought to be doing is taking the momentous decision of Obergefell. I went to law school, first semester of law school in 1986 at Emory. And that was 3 months after Bowers v. Hardwick had been decided by the United States Supreme Court. We've gone from Bowers v. Hardwick to the Rome decision to ultimately to Lawrence v. Texas. We've gone that entire sequence of cases, and now resulting in Obergefell. The best line from Justice Kennedy in Obergefell relates to the fact that he talks about going from outlaw to outcast is a good first step, but doesn't fill the full promise of liberty. Do we want to create a situation where we are kind of piecemealing this in a way that leaves some same-sex relationships in one category and another set of same-sex relationships in another, and completely then dependent on the ability to litigate issues? I don't think we want to do that. I would submit to this court that the practical response to this is to affirm the Court of Appeals and urge with the family law section, as they did in Barnes, as they've done many, many, many other times, to address this issue in a comprehensive way through the legislature. I thank the court for my time.
Thank you.
Before I begin, may I inquire as to how much time is remaining?
1 minute and 10 seconds.
Okay, we'll see what we can do. So to first address your question as to whether or not we should overturn Van, I think that depends on whether or not we decide to implement more than an expansion of the equitable parent doctrine. I would be happy to brief the court on that. If that is something that you would like me to do, I would be more than happy to. With regard to the notion that parties could have gotten married in Canada, I would like to offer to the court that that's inaccurate to the extent that it would not have been recognized here back in the States. Furthermore, according to our statutes, the way that it's written, same-sex marriage would not have been recognized. So it wouldn't have mattered where they went to get married. In 2008, the only place they could have legally wed was Massachusetts, and that was the year that the child was conceived and born. With regard to opposing counsel addressing Barnes v. Juvedine, I did just want to point out that that is not regarding a same-sex couple, and that's exactly the point here. Your Honors, respectfully, we're asking for the playing field to be leveled for both heterosexual and same-sex persons, and that's why there are requests out there to not only require marriage when it comes to these remedies for same-sex couples. There is not an option for adoption proceedings for same-sex couples at the time that the parties split, and I want to be very clear about that. And I would welcome you to re-review the ACLU Amicus brief, wherein that's specified, and there's a timeline and there's a law linked back to that. And then respectfully, I would offer we do not need a legislative-only approach. I think that we're more than capable of working with what is in front of us, and that is requesting a non-biased interpretation and open reading so as to expand what is currently within Michigan law to apply to same-sex couples so that they can achieve standing and get the custody and parental rights that they so deserve. And then finally, I would offer that the family law section didn't want to expand on the equitable parent doctrine, and they said specifically in their brief that they had concerns because it was not codified law. So I would like to direct your attention to that as far as being their reason, not what opposing counsel offered. I believe that my time is up. Are there any questions?
I don't see any. Thank you very much. The case will be submitted, and the court stands adjourned until tomorrow morning at 9:30.